Hello and welcome to Legalese. My name is Vince Perryman and I am a local attorney with the law offices of J. Vincent Perryman. Each month, Legalese focuses on a wide range of legal issues and topics. Today's show covers estate planning. With us now is Bill Jones with the Jones Law Firm. Bill, thanks for being back with us.
No problem. Good to be back.
And when we talk about estate planning, it goes from the simple to the complex. And I know, I do a lot of the complex stuff and you handle some of the simple stuff. I guess a great place to begin is just sort of where the demarcation point is between the complex estate planning and the simple estate planning.
Sure. Probably though, I don't know in your practice, but in mine, I'm going to probably gauge it around $500,000. Now, when we talk about that $500,000 figure, we're not going to include life insurance policies, anything basically that you can write down who is going to be entitled to it. We're not going to include that. But if your assets are above $500,000, I'm probably going to send them to somebody like you that knows a little bit more about tax law.
Right.
I know that that's kind of your forte, whereas I avoided the building where tax law was taught. So that's where I'm going to make the dividing line. In a practice like yours, what's going to be your dividing line?
Well, as far as generally what we look at is we've got to look at even the accounts and the life insurance and everything, because for tax purposes, very much it may be included or it may be excluded. It just depends. And some of it depends on where properties are situated, because if you've got a $1 million home in X state, that state may have an inheritance tax, so it may come subject to that. So for us, generally we look at it with about the $500,000 mark and say, okay, if we're just at $500,000, then chances are we're probably not going to hit a taxable estate. But we do that with a caveat of, are those assets appreciable? Because homes always go up in value, and some of that depends too on the age of the individual. So generally we may start off with a rather simple plan, and it may develop into a complex plan over the years. So, I think basically there's some basic documents that I know you're talking about them all the time, yeah, that we require in those estate plans. So, with the simple wills and the power of attorneys, whether there's a general and one for health care, and then the living wills. And I know, you're licensed in Mississippi as well, and sure, there's a few nuances with those. There's
some differences. I mean, mainly what I do, basically I'm a family law firm, and a lot of times after there's been a separation or an addition, after an adoption takes place or after a divorce takes place, that's kind of how I got into it. With some of these lower estates under $500,000, what we'll do is we'll come in and we'll say, okay, it's a new beginning. There's been a major life-changing event for you. Let's draft you a will, a living will, power of attorney, and a power of attorney for health care. And that's what I'm going to tell folks is every time there is a major life-changing event that they need to revisit their will. For example, if they come in to see me and I do a simple will for them, and then down the line they either remarry or mom or dad passes away and leaves them a sizable inheritance, something that I drafted is not going to give them the same type of benefits for something that you could draft. So what I'm going to tell folks is if you have me do these simple documents, these simple wills for you, they'll probably work until you get to a point where they're going to need somebody with your expertise in that area.
Right, and that's the thing I run into a lot of times with the estate planning is, people are like, oh, well, so-and-so will write me a will for $125.
Sure.
Which is great, but they don't seem to understand, and it's hard to get that concept of this is a fluid document, that it's ever-changing, because not only are tax laws changing, but also your circumstances are changing as far as more kids. You may have a child that unfortunately has problems. And whether those be medical problems or, financial problems or a gambling problem, alcoholism, things like that, you may need to do something very much different to make sure that that child is taken care of and you protect what you leave for them from the creditors. And it is interesting because, you have a lot of people that they're very afraid of probate. So they've been sold on the revocable trusts, which are these living trusts, if you will. And, essentially...
Now let me ask you, I don't do trust. So from someone in my planning point that doesn't do a trust, what is it? What is a trust? Just a boilerplate example.
Well, in this situation, what we're talking about is a revocable trust. So the trust is a fiction, if you will, and it's basically a holding area for all of this individual's assets. So it actually requires two documents when we do one of these, which is a trust document that says, I transfer all of my assets, both real property and personal property, and to this trust, which I have the right to revoke at any time during my life, and when I pass away it becomes an irrevocable trust, and this is who all it passes to. Now that keeps them out of the probate court. Now it doesn't keep you out of having to deal with the IRS or having to deal with your State Department of Revenue. And what everybody has to do is you have to make sure that you've transferred your assets into that trust. So say you buy a new vehicle, it needs to be titled in the trust's name, not in your personal name. Otherwise, it passes outside of the trust, and then what we have is a document called a pour-over will, which is sort of the catch-all that says, hey, if I forgot to put something in the trust, then it goes into the trust. But you still have to step into probate court to take care of that.
Now, at what point does it make sense to start looking at a trust? I mean, if I've got a baseball card collection valued at $1,000, does it make sense to go out and put that into a trust? If I've got a house worth $20,000, does it make sense? At what point is it a good practice to think about doing that?
Well, in that situation with the revocable trust, some people they're afraid of what the court system will do, things like that. So if there is a problem with that, then and if you're interested in privacy, then the revocable trust is very much appropriate. When we return, we will continue our discussion about estate planning. Please stay with us.